So the ATF just suffered a huge loss in the lawsuit against their regulation of forced reset triggers. So let's talk about this. But real quick before we jump into this video, if you think these ATF rules are clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have dedicated roasts for organizations like FBC and GOA. So if you buy some of their coffee, you are directly donating to 2A organizations that help to file lawsuits. So again, amazing coffee. You can check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we're going to be discussing a recent order which was issued by a federal court judge, which is blocking the ATF's current attack on forced reset triggers. The case we're going to be breaking down in this video is NAGR v. Garland. Now, this is something that hit a couple days ago, but I wasn't able to cover it because I was out at the Route 66 Shooting Sports Park event. I got to meet a ton of you guys out there, so thank you to everybody who came out. But while I was out there, this order hit, and a lot of you were asking me what is going on with forced reset triggers, what is going on with this new order from Judge O'Connor. In his recent order, Judge Reed O'Connor enjoined the ATF from enforcing their FRT rule against plaintiffs in this case, along with NAGR and their members. Now, for me to break this down, we have to go through a little bit of groundwork because this has been a multiple year saga between the ATF and then also the Rare Breed Triggers Company. Back in July of 2021, the ATF sent a cease and desist letter to Rare Breed Triggers. In the letter, the ATF claimed that in their eyes, the Rare Breed FRT-15 forced reset trigger meets the NFA and GCA's definition of a so-called machine gun. Because of this, the ATF claimed that triggers were subject to the registration, taxation, and possession restrictions like actual machine guns are. Also, the ATF claimed that the possession of these triggers outside of the GCA and NFA's restrictions would subject people to criminal penalties along with fines. In the letter, the ATF told Rare Breed to cease and desist the manufacture and transfer of all of these triggers and to contact them so that they could figure out what they needed to do with all the triggers that had already been sold. Rare Breed did file a lawsuit against the ATF in the Middle District of Florida originally, but ultimately that case was thrown out because some court filing deadlines were missed. And then the company Rare Breed Triggers filed a different lawsuit. I believe that was up in North Dakota. That lawsuit was also then thrown out because the court said that it lacked a venue to be in North Dakota. Recently, however, Rare Breed Triggers partnered with NAGR to file a lawsuit against the ATF in the Northern District of Texas, and the case was currently put in the hands of Judge Reed O'Connor, who is also responsible for a lot of wins that we've got out of the kind of Fifth Circuit area. You may be familiar with the Mock case, the Pistol Brace case, and then also the Vanderstock case, which deals with the ATF's rule on unfinished frames and receivers. Judge Reed O'Connor is responsible for all of those cases. Now, while all this was going on, there was also another lawsuit which was filed by the US government against Rare Breed Triggers, and that was in the Eastern District of New York. In that lawsuit, the government alleges that the triggers being sold are in fact machine guns under the NFA and GCA. The government also alleged that Rare Breed Triggers was engaged in mail fraud, wire fraud, making threats to the ATF and other federal agents and courts, and then also engaging in other misconduct. Now, on review, ultimately, the federal district court there in New York ruled in favor of the government and granted their preliminary injunction against Rare Breed Triggers and then also Rare Breed Firearms. That injunction prevents the company Rare Breed Triggers from engaging in any sales or marketing of various FRT triggers and then other devices. But now we just got an order from Judge O'Connor that he has granted a preliminary injunction against the ATF and their regulation of forced reset triggers, which is a huge blow to the ATF and their current overreach. Judge O'Connor, in reaching his decision, used the en banc panel's decision in Cargill, which dealt with bump stocks, to essentially strike down what the ATF is trying to do here with forced reset triggers. Both of these dealt with the redefinition of so-called machine guns, trying to expand that definition to include other items, so Judge O'Connor used Cargill to also attack this specific case. Now, to win a preliminary injunction like what just happened in this case, you have to show there is a substantial likelihood of success on the merits, that irreparable harm was suffered, that the balance of hardships is in your favor, and then also that what happens here is in the public's best interest and will not harm the public. Judge O'Connor, in reviewing those factors, found that a preliminary injunction must be granted in favor of the plaintiffs here in this case, along with NAGR and their members. In his order, he ruled that plaintiffs are likely to succeed on the merits, which again is huge, and that is one of the main factors. And usually if you show that, then that means you're going to win the case and also win the injunction. Here, plaintiffs contend that the ATF's regulation broadening the machine gun definition is an arbitrary and capricious expansion of the agency's authority. Plaintiffs are likely correct. Accordingly, the court concludes that the plaintiffs have carried their burden at this stage to show that the expanded definition of machine gun likely exceeds the scope of the ATF's statutory authority. Therefore, plaintiffs have satisfied arguably the most important of the four factors. Judge O'Connor then goes on to point out that the Fifth Circuit's en banc panel decision in Cargill also controls this case. He then goes on to also reject the government's argument that he should essentially adopt what the federal district court in New York said about this specific case. The ATF and the government argued that he should simply just follow what the New York court said. But here, Judge O'Connor says, I'm not controlled by that. What I am controlled by is what the Fifth Circuit said in Cargill. And that cuts against you directly, the ATF. This would cut against your new rule and your regulation of forced reset triggers. He states in this decision that applying Cargill's holding here, FRTs do not fire multiple rounds with a single function of the trigger and do not qualify as machine guns. He also later goes on to reject the ATF's argument that since the rate of fire for FRT rifles or rifles equipped with FRTs is similar to automatic rifles, that all of a sudden they're magically machine guns. In response to this, Judge O'Connor also stated that if Congress wants to amend the statutory definition in the future to define machine guns based on the rate of fire or absence of a disconnector, it knows how to do so. Until such time, a comparable and even identical rate of fire in absence of a disconnector have no bearing on whether a firearm is a machine gun. Therefore, he states, those comparators do not alter the court's determination that FRTs most likely are not machine guns. So there he's rejecting this analog that the ATF is trying to draw between rate of fire. He's saying that's not in the statute, that's not in the statutory language. If Congress wants to try to do that and amend it, that's their job, but that's not your job, ATF. And based on all that, he finds that the plaintiffs are likely going to succeed on the merits of this case. Judge O'Connor also goes on in the order to look at the irreparable harm, and he says that there is clearly going to be irreparable harm, and he finds irreparable harm because there's a credible threat of prosecution by the ATF against other individuals and also plaintiffs in this case. He points out that the ATF has already come to the homes of plaintiffs in this specific case, and then also other individuals as well. Finally, he found that the public's interest is best served by there being an injunction on this issue. Again, the government here cannot show that they're going to be harmed in any way, but there is clearly going to be harm to the people. Based on that, Judge O'Connor granted a limited injunction in favor of the named plaintiffs along with NAGR and its members. Judge O'Connor denied the request for a nationwide injunction, which is important. I want to note that he denied a nationwide injunction using kind of some of the language that was recently issued by the Fifth Circuit in Mock. He wanted to leave this limited. There was a request for a nationwide injunction, but instead it's going to be specifically to the plaintiffs in this case, and then also NAGR and their members. But also within his order, he added in a clarification section that said that his order would not override what the federal district court in New York said on this issue about the ability of Rare Breed Triggers in this company to continue to sell and market FRTs. He stated that Rare Breed is carved out from the protections in this order, but maybe other companies that are members of NAGR could be protected if they're members in some way. But specifically, he is not going to disrupt what the New York Federal District Court said in their decision about Rare Breed and being able to sell and market. Instead, they're carved out. But primarily, the protection from Judge O'Connor's order is going to be for the named plaintiffs, NAGR and their members, maybe other companies that are members of NAGR. But because of that prior decision by the New York Federal Court, the Rare Breed Triggers is not going to be impacted specifically by this lawsuit. Now, as always, yes, you guys, I'm an attorney, but this is not legal advice. However, I do want to warn everyone watching this to be very careful proceeding forward on this specific issue with these specific items. The ATF has been very aggressive when it comes to the possession and sale of FRTs. This injunction is limited at this time to plaintiffs and then NAGR and their members. But keep in mind that similar relief has been granted in other cases like the Vanderstock ATF frames and receivers lawsuit, and then also the pistol brace lawsuit. We're going to have to wait to see how the ATF decides to move forward, but the ATF has tended to just appeal these types of injunctions being granted. And so I have no doubt that they will do the same thing in this case. So again, I just wanted to warn everybody, although we did get a favorable decision, although an injunction was granted for plaintiffs, NAGR, and their members, no doubt in my mind, the ATF will appeal, and then we'll have to see how this proceeds forward from there. That's what's going on. It was still a huge, significant win in favor of the Second Amendment against the ATF and their overreach, but we will have to wait to see how this plays out. And as I get more information, I will let you guys know. So if you guys like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, the station was built by armed scholars, and the station will be maintained by armed scholars.